Judge Boyce. I'm appearing from Madison County, my chambers here for this hearing this morning. This is case CR 22-20-755, State versus Chad Guy Daybell. This is the time we have scheduled for a hearing on a motion for joinder. The state filed its motion for joinder on September 1st, requesting that this case be joined with a different matter, which is case CR 22-20-838, State versus Vallow Daybell. The defendant in this case objected to the motion for joinder, filed that objection on September 9th. And Mr. Pryor also submitted a notice of authority on October 22nd. And I will just note as we get started here, Mr. Pryor is appearing with his client, Mr. Daybell, on behalf of the defense. Mr. Wood is here on behalf of the state, and we are conducting this hearing via Zoom pursuant to the Supreme Court's operating order. In the other separate case, the 838 case of Mrs. Daybell, she did file a notice of non-objection on September 14th, so it's not being objected to by the other defendant. So this is the time set for argument on the motion for joinder. Mr. Wood, is the state ready to proceed with argument this time?
Yes, Your Honor.
All right, Mr. Wood, it's your motion. So if you want to go ahead and present argument, and then I'll hear any response from Mr. Pryor.
Thank you. Your Honor, Idaho Criminal Rules 8B and 13 establish the standard by which a court decides if two defendants should be charged and tried together or if joinder is appropriate. Rule 8B states that it's appropriate for two defendants to be charged together if they are alleged to have participated in the same act or transaction or in the same series of acts or transactions constituting an offense or offenses. It also establishes that each defendant does not need to have identical charges to do so. Rule 13 gives the court the authority to order that two or more complaints, indictments, or informations be tried together if the offenses and defendants, if there is more than one, could have been joined in a single complaint, indictment, or information. In the case before the court, Chad and Lori Daybell are both charged with 2 counts of conspiracy to conceal, alter, or destroy evidence. Chad Daybell is additionally charged with 2 counts of concealing, altering, or destroying evidence. The evidence in question for all counts is essentially the same. That evidence is the deceased bodies of Lori Daybell's children, Tylee Ryan and JJ Vallow. Both of the deceased children were found on Chad Daybell's property in Fremont County, Idaho. They were found after law enforcement discovered a text from Chad Daybell to his now deceased wife, Tammy. Matching that text with geolocation data from the phone of Lori Daybell's now deceased brother, Alex Cox, gave law enforcement the location of the children's bodies. The Daybells are charged with conspiracy because the evidence which the state will present shows that there was a plan between the defendants in regards to the fate of Lori Daybell's children. The evidence in this case, the state believes, will demonstrate that the concealment of Tylee and JJ's bodies are the result of the same plan and the same series of acts or transactions which constitute the offense for which both defendants are charged. And that is the standard set forth in Rule 8B. I note that the standard is the allegation that they are alleged to have committed those acts. Beyond Idaho's criminal rules, the courts have made it clear that joint trials are appropriate. As mentioned in the state's brief in Zafiro versus the United States, the Supreme Court stated that joint trials play a vital role in the criminal justice system, that they promote efficiency, serve the interest of justice by avoiding the scandal and inequity of inconsistent verdicts. Currently, the defendant's cases are assigned to 2 different judges. This is highly inefficient as it requires duplicative work from 2 judges, their clerks, and their staff. It requires the state to perform duplicative work by creating a need to litigate similar issues twice in front of 2 different courts. This raises one of the most important issues in front of the court, as in most criminal cases, issues of evidence will be litigated prior to trial in these cases. It's inevitable. The trial court has varying degrees of discretion over the admissibility of evidence. As these cases are currently situated, it's entirely possible that an issue of evidence could be decided upon differently by 2 different courts. The state believes that could create automatic issues of appeal if that decision is beneficial to one defendant and yet harmful to another defendant. At this point in the proceeding, the requirement that the defendants receive a fair trial is better served by consistent pretrial rulings, which would help avoid the inconsistent verdicts discussed in Zafiro. In Bruton versus the United States, the Supreme Court stated that joint trials conserve state funds, diminish inconvenience to witnesses and public authorities, and avoid delays in trials. The witnesses in these cases are the same witnesses discussing the same evidence. And I'd ask the court to consider the fact that if these cases are tried separately, or even litigated prior to trial separately, that creates a great inconvenience and hardship on witnesses who live out of state. Witnesses in this case live in the various states of Idaho, Arizona, and Hawaii, and possibly others. Separate proceedings will create a great cost to the state in bringing those witnesses in for essentially duplicative testimony. The Ninth Circuit Court of Appeals in the United States versus Jenkins stated that joint trials are particularly appropriate where co-defendants are charged with conspiracy. The Idaho Court of Appeals in State versus Blake stated that an appropriate and fair trial can be accomplished in a joint trial, and the benefits of a joint trial in light of the allegations of conspiracy, as well as the need for the same witnesses as evidence, can outweigh other concerns. It's the state's contention that the rule for joinder should be construed broadly to allow liberal joinder to enhance the efficiency of the judicial system. One issue we did not discuss in our brief, but the state feels is very important, is the effect separate trials will have on pretrial publicity. There can be no question that separate cases requiring separate hearings will create more pretrial publicity. Consider the explosive nature of a story in which two different courts reach two different decisions on the same question of law or fact. The state has gone to every effort to protect both defendants' right to a fair trial, even asking the magistrate court in this case to refrain from broadcasting the preliminary hearing. Again, separate cases absolutely means more hearings, more media coverage, and more difficulty in finding a suitable jury. Mr. Daybell has provided the court with State v. Nava, as we discussed prior to this hearing. I would point out that Nava deals primarily with Rule 8A, which governs joinder of offenses, whereas the state is asking the court to make a decision under Rule 8B, which governs joinder of defendants. Nevertheless, the state acknowledges that joinder of offenses and joinder of defendants shares a similar analysis. It's important to note that the decision in Nava hinged on whether the defendant's multiple offenses shared a common scheme or plan. In the case before the court, we aren't litigating a common scheme or plan, we are litigating a conspiracy, which is the same scheme and the same plan shared by co-conspirators. Nava is instructive in its discussion of Idaho Criminal Rule 14. At the end of the day, the defendants must have a fair trial. If the defendants believe that joinder will prejudice them at trial, they may object and present evidence to the court on those grounds. At this point in the case, the court lacks enough information to make any such decision. Even if this court did find at some point that separate trials were necessary to protect the defendant's rights, at this stage in litigation, the requirements of justice and efficiency are better served by joinder of the defendant's cases under one court with one judge. A decision to join the cases now does not preclude the court from hearing argument under Rule 14 at a later time. The defendant always has the right, both defendants have the right to make that motion at any time prior to trial.
That would be a motion to sever that you're referring to?
Yes, thank you, Your Honor. A motion to sever under Rule 14. I would, as the court noted, the defendant, Lori Daybell, has filed a notice of non-objection to the state's motion for joinder. Finally, Your Honor, I would ask the court to consider the effect of keeping the cases separate, the effect that will have on the families of Tylee and JJ. They are victims in this case as well and have a right to be present at any physical proceedings it may have. Who knows how that will play out with COVID, but it's entirely possible that we will have many of these proceedings live. None of the close family members of Tylee and JJ live in Idaho, whereas due to the fact that Tylee and JJ moved to Idaho very soon before their deaths. And I'd ask the court to consider the hardship on Tylee and JJ's brother, the Woodcock family, the Vallow family, and the Cox family in keeping these proceedings separate. Consolidating these cases creates less hearings and less travel for those victims, and as such, less hardship. In conclusion, Criminal Rules 8B and 13 allow this court to make a decision to join these cases. The standard for joinder again, is that the defendants engaged in the same acts or transactions or series of acts or transactions constituting an offense. And in this case, that's heightened by the fact that they are alleged to have engaged in conspiracy. The state believes the standards clearly met in this case. Further, the defendant's right to a fair trial are protected by Rule 14 and the possibility of a motion for severance at a later date if necessary. And as such, the state respectfully asks this court to join Chad and Lori Daybell's cases into one case.
All right, thank you, Mr. Wood, for the argument. Mr. Pryor, argument in opposition.
Yes, Judge. Judge, I took the liberty of submitting State versus Nava to the court. I'm fully aware, and I appreciate Mr. Wood pointing out that Nava addresses 8A, but I think the analysis is the same. I think in good faith, I can't argue that the allegations, and I want to make it clear that they are allegations against Mr. Daybell and Ms. Vallow are similar in nature, and that under the prong of 8B, it applies, and the joinder does apply. The objection, Judge, that I filed talks about prejudice. Further, I appreciate that Mr. Wood recognizes that at any time in the future, I can file a motion for severance under 14 and say that trying these two folks in the same proceeding is highly prejudicial. Mr. Wood and I have discussed, and I'm not going to make a matter of this, but there's still some housekeeping that needs to be done in terms of discovery that Mr. Wood and I are going to privately engage in trying to resolve, and if necessary, we'll ask the court's assistance. But at this point, without all of the information in this case, I'm not in a position to argue severance on this date, and that's going to have to be reserved for a different date. But Mr. Wood's argument, Judge, to suggest a convenience to the court and expense to the county and the difficulty of witnesses is secondary. And primarily, Judge, the importance is Mr. Daybell going to get a fair opportunity to present his side of the story? And is it going to be able to be presented without any kind of prejudice or bias? Or are they going to infer anything from any other witness or any other defendant or anybody else that does not afford him an opportunity to fairly present his case? And although 8A doesn't specifically address bias, the Nava case talks briefly that there is still a prejudice or a bias, and the court can evaluate that. Now, I understand there's been an inordinate amount of publicity. Mr. Wood has pointed out examples of some of the publicity, and I've pointed out examples, and that's going to be reserved for a different date in November when we talk about venue. But the fact remains, Judge, that by linking the two of these folks together is still going to provide a modicum of prejudice. And although I have to concede that joinder, when you look straight at the rule 8A, that there is an allegation of similar facts in this case. The fact remains is what I would ask the court to do is reserve a ruling on joinder, allow the argument to be made in terms of severance once Mr. Wood and I have resolved our discovery issues, and decide at that point whether or not we're going to proceed in a common trial. I don't think it's an effective argument for Mr. Wood to suggest that he's going to have to make more effort and he's going to have to do duplicative work in two different cases. And I'm sorry that he's going to have to engage in that. But the fact remains that
I'm a little confused on, we don't get to severance without a joinder because right now we do have two separate proceedings before two separate courts. So I guess I don't quite follow the argument of reserving ruling on joinder and then argue severance later.
well, and that's
actually where in all we are, you could call it severed because we have separate proceedings, separate judges right now.
I guess my feeling, Judge, is simply this, is that if the court joins the case, you're going to require the fact that I go through the analysis and we come back and there's going to be a continued hearing. Now the court understands it. Maybe I wasn't being particularly clear. I guess from my position is I would leave the status quo, because at this point, we are going to be going back and arguing these same facts again in a severance case once again, and I'm not beating on this, Mr. Wood, please don't take it this way, but once Mr. Wood resolves some of the outstanding issues that we have yet to resolve between the two of us. I guess from my perspective is that we proceed along as we are proceeding, and if at some point there needs to be a further ruling on the joinder, at that point we can go forward and do both of them at the same time. If the court doesn't want to do that, the court can make its ruling, and obviously I think both of counsel and I have indicated to the court there is the opportunity, without further action, for a motion for severance in the future, Judge. Thank you.
All right, thank you for the argument, Mr. Pryor. Mr. Wood, if you'd like to make any final rebuttal argument, you can do so.
I would just point out that the duplicative nature of work in this case, if the cases aren't joined, and the inconvenience that causes not only the state but witnesses and victims, is absolutely appropriate for the court to consider. It's one of the factors brought up in the case law presented to the court. Other than that, I have nothing else, Your Honor.
Okay, thanks, Mr. Wood. Well, counsel, I've considered the motion. I'm prepared to make a ruling at this time. As I mentioned when we started the hearing, this motion's been pending for quite some time. It was filed on September 1st, so almost 2 months ago. The concerns the state brings up as reasons to join the cases at this time I've considered, and I have to look at the two-prong analysis that's set forth in the case law and supported by the rules under Rule 8 and Rule 13 of the Idaho Criminal Rules. And the two factors I look at is, number one, under Rule 8B, is there a common scheme or plan to support the joinder that is alleged to have occurred in these two cases? And then part two is, would a joint trial of the two defendants be prejudicial, looking at joinder under 13 of trying the cases together. So as I mentioned at the outset, in the other case, which is Mrs. Daybell's case, CR 222838, there was filed a notice of non-objection, and that is part of the consideration. But looking at the first prong, I think that's easily satisfied under the allegations of the two cases. In each case, there's been a complaint filed in one. In Mr. Daybell's case here today, that's an amended criminal complaint filed on June 30th. But both cases have charges of conspiracy to commit destruction, alteration, or concealment of evidence. And in each case, or each complaint, I should say, that's pending in both cases, there's a list of overt acts that are alleged to have occurred in support of the conspiracy charges, and two separate sets of overt acts. When I review those complaints, the overt acts are identical as to both cases, and the charges themselves all relate to the common evidence the state would bring forward at trial and the common witnesses based on those conspiracy charges. So it's pretty clear that the first prong of whether or not there's a common scheme or plan is supported under Rule 8B for joinder of the offenses in this case. And then looking at whether or not the joint trial of the two defendants would be prejudicial, there was an allegation in the response that was filed that this would create additional publicity, which would prejudice the right of Mr. Daybell to a fair trial if these cases were joined. I've considered that. I've also considered the arguments of the state that having two separate courses run in two different cases with two different judges could result in separate evidentiary rulings. There could be some inconsistencies. There would be duplicative hearings. And I think quite concerning given our circumstances right now under our COVID restrictions and the difficulties we have even getting a jury trial at this point. The prospect of having two separate trials where two separate juries would have to be impaneled to try each case is concerning as well. And so when I look at all the factors and the supporting case law, I don't find that the prejudice at this point has been demonstrated that would be sufficient to prevent me from joining these cases. And so based on the analysis and consideration of the citations also provided by Mr. Wood, and also in due consideration of the new case that was cited by Mr. Pryor, the Nava case, I read through that as well. I do find the facts of that somewhat inapplicable to the issue I've got at hand. That's where a single defendant had a trial involving separate multiple victims, which were put together in a single trial. Here we've got two defendants with a single common scheme or plan that is alleged. And so upon consideration of all that, council, I am going to grant the motion to join at this time. As the parties indicated, that doesn't forego the possibility of a future motion for severance if prejudice is demonstrated by the defense in support of that motion. So clearly, Mr. Pryor, you have that opportunity going forward if you believe the prejudice would exist after we get further down the road with these cases being joined. But I am going to order the joinder of the cases. I'll grant the motion. Then, Mr. Wood, if you'd submit appropriate order, I'd appreciate that.
Yes, Your Honor, we'll prepare that order.
All right. Mr. Wood, do you have any questions regarding my ruling today?
No, Your Honor.
All right, Mr. Pryor, any questions from the defense regarding the court's ruling?
No, Judge, thank you for your consideration this morning.
All right, thank you very much, counsel. I appreciate your preparedness this morning and your briefing and arguments. And if there's nothing further, then we'll be in recess.
Thank you,
Thank
Judge.
you.
Guys, I'm not gonna come on right now because I slept in too late, and yeah, I found it just in time because I got up, or I stayed up too late. I stayed up till 8. You guys, I figured out the issue. I have a little solution to the issue about seeing over my walls or whatever, because you could put like a well, I'll show you, like a back, what is it called? Hold on. That's what I stayed up all night while I did the thumbnail. And then I was doing the overlay. So when I do my lives, I could put an overlay. So I had to find the right measurements. Oh, wait, hold on, guys. Oh, you guys don't even hear that, huh? Just me. This other thing is playing. So I had to do like the right measurements to fit the wall where it like came up. You'll see what I'm talking about. So it took me forever to like cut it just right. And it's like an overlay. So I didn't have to put the camera up just as high. It still has to be tilted, but it's not as tilted. So I'll show you guys in the next live. But thanks for coming. I might try to do one tonight. I'm going to try to get a couple more hours of sleep because I only slept like 2 hours. So yeah, because I got to pick up my computer too later too. So yeah, hopefully maybe tonight or tomorrow or something, because I want to do a live soon here. So this week before the weekend. So thanks everybody. And joined her, yay though. Sorry, didn't even talk about what just happened. I'm pretty happy. Either way it would have been all right, but I guess it would. I think it makes more sense for the joinder. You guys probably all agree too. I just, it'll be one trial. It saves money. I mean, they would have had to get 2 juries and 2 sets of resources to do the trial twice. So I think it makes sense. I think Pryor's going to fight it. He's going to find other reasons to try to fight it and dismiss it or whatever you call that, or he could try to go against having it. But I think, I don't know if he'll stand a chance now. If he could think of any other issues that he could use to fight it, but yeah, I don't think he has a chance. So I think it's going to be joined, guys. So yeah, hopefully you'll watch it here because I'll be live streaming it. It probably be like at least a couple week trial, if not longer. Now that they're joining it, I know they scheduled off I think almost 20 days. I have to look at the dates that they scheduled off for when they text you, the dates, but they might even add more. Oh wait, they still have to do the change of venue request. Did they even cover that? So if that ends up changing venue, the dates could all change. I don't know if they're going to do that on the 24th. Or what's going to be on the 20th? Oh no, the 24th is supposed to be the dismissal one. Pryor's still trying to get the whole thing dismissed. I forgot about that. Remember that got moved up till November 24th. He's going to try to dismiss it like there's not enough evidence to try Chad. I forgot about that. And then maybe that's when they'll cover the change of venue. So I guess everything is still kind of up in the air. But if it all goes as planned, I think it was scheduled to start on January 11th. But like I said, since they joined them, I mean, that could change a lot. So we'll keep you updated. And I'm I'm sure it will be sometime in January or sometime around that same time. But all right, guys, I think I am gonna go. Oh, hey, Zanita Rivera. Let me say hi to a few people. Don Marie and Mary Wilcoxon. Christy Flanagan. Wait, why'd you say sorry? Christy? Oh, okay. Oh, I'm glad you're liking it. Oh, because you wrote it wrong. Okay, no, that's fine. You know how many times I write people's names wrong? Because that stupid autocorrect. It gets you every time. It's like even if you try to correct it, sometimes it keeps changing things. I hate this autocorrect sometimes. It makes us look like we're idiots sometimes, like we don't know how to speak English. Oh, no problem, Alice. Just start if you want to watch it from the beginning, just watch it from the beginning and it goes right to it because I got it just in time. So you just start this. So well, it'll be uploaded I'm gonna upload this so that you'll be able to see. Yeah, I think I am gonna get a couple more hours of sleep and then go get my computer. What was I gonna say? Yeah, so hopefully I'll show you guys what I did with the camera thing. I hope you guys don't think it's stupid, but it's the only solution I could find where I don't have to have it so slanted. I don't know why I just said that because I just looked up at the camera. That's probably why I just was looking at it because this thing keeps falling off. I might need to take it back and get a new one because the top keeps falling off of it. It's gonna be good. I can't. Good. Keep watch. Yeah, I know the trial. I can't wait for the trial. I feel like there'll be a lot of answer questions that we've been all wanting. I hope it's not one of those trials that leaves you like, oh my God, they didn't tell us anything. Like, what was some of those trials? Well, for instance, Casey Anthony, they never were able to tell you the cause of death or anything like that. Do you think they ever got the cause of death on Tylee and JJ? Wonder if it's going to be one of those where they weren't able to tell. And then just, I don't know, everything, all the like all the information they got on everybody. So hopefully it'll be good. Wait, no, I accidentally did something. Okay. All right, guys, I think I'm gonna go before I start rambling on about silly stuff. Cowgirl. Yeah, it was really quick. Just start it from the beginning and you'll see it starts right away. I won't tell you what happens if they joined him or not. I'll let you just watch so you could be surprised. Unless if you want to know. I'm sure you could tell by the chat if you look through it though. I know, yeah, I'm happy to on it. I figured, I mean, that would be silly not to. I loved Zeke's little emojis. I love seeing him in the chat. He's so cute. He came running up when he heard me up and I was actually watching some of the hearing laying on the bed with Zeke when I was watching it on my phone, as it was on my laptop, live streaming, but he came up running all excited. So he jumped up on the bed. So I was laying with him watching it. So sweet. So cuddly. All right, guys. Save Robbie, what's up? Good morning. We got to do a live together. Me, you, and Mexi should do something. I should come to Colorado and do one of your investigations with you. I don't even know if you're still here because I think that was a while ago, huh? Or no, that message wasn't too long ago. But I was answering the other ones before I saw that. Sometimes I go back because I miss them. I'm going to have to catch up on some of your videos. Save Robbie, you crack me up. I might actually do that right now. Just lay in bed, go back to sleep, and watch a couple of your videos. All right, guys. Sad soul, I'm so glad you made it, though. It's your time, huh? Look, people are dropping off the chat. They're like, okay, you're rambling. We just wanted to see the hearing. Sweet crazy, it's nice to see ya. I know, Rain Dance. I just feel like it's harder for somebody to convict, like with Casey Anthony. The fact that they don't know like how Kaylee died and where she died, it was hard to put the story together to say guilty, so I feel like it's really important for a jury to hear the story, listen to Zeke, of how, if they could tell, if the prosecution can tell how and where and convince the jury that it was them that did it, they need to know the details. So I feel like it's very important to know those details to present them to the jury to get a conviction, in my opinion, for a trial. So that's why I'm hoping that they were able to find out something, because they got to convince that they know how and where, at least. I feel like, I mean, they could still get a guilty verdict. Look, Scott Peterson, the perfect example. They couldn't show exactly how or where that happened, but it's just, it helps, you know. Zeke. Yeah. He's like, yeah. Yeah, sweet crazy. Yep. They couldn't, yeah. So I think if they were able to get the cause of death for Casey Anthony and tell more of the story to the jury, I think they could have, you know, got a guilty verdict for her. But yeah, they couldn't do that. So I'm just hoping, not that, like I said, not that that means that they won't convict them, but it's just a better chance, you know, because they want to hear, like, they know that they did it, how and when, and it just helps you guys. But to me, I feel like there's no way that they can't find him guilty. But I'm sure Casey Anthony, I'm sure, I mean, we were all thinking that there's no way that she's going to be innocent. Everybody knows she was involved, but they couldn't show that. So that's why I'm hoping that Rob would. I don't know. I hope he has this down. I hope he's got some good information, guys. He worries me a little bit. I mean, I feel like he's all right, but he's not like as strong as a prosecutor as I've seen, you know. I don't feel like he's like one of the best that I've seen. That's all. But hopefully he's good enough. So, he's just not really like I feel like he wasn't really that effective on the preliminary, because we got to see him in the preliminary. It wasn't like he was like, man, he did a good job. It was the evidence and it was everything that was good, but he wasn't really that effective in presenting it to me. So I just hope he has a lot of evidence, or he just gets better or something. But I mean, I doubt he's been doing it for how long. I'm sure that's what we're gonna get. So hopefully he has a lot of good evidence, I guess. No murder charges, actually. It's just a conspiracy. So he should definitely be able to get this, because I mean, they did. That's true. It's not murder charges. What am I talking about? Duality, reality. They don't have to show the cause of death and stuff. This is just the conspiracy charges. Oh my God, you're right. So they better at least get them on this. Yeah, that would only apply more to the murder charges, if they have murder charges. I was like looking at this like a murder trial, but you're right. It's not. I keep forgetting it's not even freaking murder. It's just this conspiracy stuff, like to conceal and that kind of, I forget all the words, to conceal, to, I don't know. I can't think right now. I haven't had enough sleep, but all right, guys, I am going to go. Megan J, what's up? Abby Barney. Yeah, Abby, I hope they do. I hope they do. They better. They'd be smart to keep some stuff, keep some stuff that nobody knows yet. Hopefully, I think they're waiting to see how this turns out. If they get a guilty verdict on this, then they might try to go for the murder charges, But if they can't get a guilty verdict on this, then how are they going to get one on the murder charges, So I feel like they're going to have to do this to even be able to do the murder. Not to be able to, I mean, they could still try it, but I mean, can you imagine if they're found innocent on these charges, then how hard it will be to get the murder charges, unless if they find new evidence or better evidence or somebody else to present it better or something. All All right, y'all. Is misbehaved here? Oh no, she said she was working because I want to do a live with her either tonight or maybe tomorrow or whenever we figure it out. So I want to test it out and maybe she could come on and because she's got a lot of information. She's got some information I want to share with you all, but she's the one that brought it to me. So I wanted to wait till she came on. It's not like a smoking gun in the case or anything, but it's just it's kind of interesting about the family. So I just want to let her share it with you guys. Okay. To put it with, I really like Nova, but I don't know what to put it with. Wait, what's Nova? Yep, Gigi Chronicles. Yep. Stated herself that she didn't want Alex to know where the kids were at after they were already dead. Wait, what do you mean she stated it herself, Abby? After they're already dead? I'm confused what you're saying. Let me think of what you're... So, except Lori stated herself that she didn't even want Alex to know where the kids were at after they were already dead. I'm trying to think what you mean by that. I mean, because she never admitted to knowing that they were dead or anything, so that's why I'm confused what you mean. I forgot I could have be putting up these comments. Oh, I wasn't even planning on, I was just planning on saying hi and leaving. Look, I'm rambling on. Like, shoot, I could be putting up some comments as I'm answering, but I better go. On the phone call with Mel. What do you mean, though? She didn't say they were dead or anything. She never admitted that they were gone on the phone call with Mel. Except Lori stated she didn't even... I know she was talking about... I mean, when did she mention Alex not knowing? She mentioned about Adam. She thought Adam was trying to kill her or something, or after her. She didn't want him to know where she was. But I can't think of what you're talking about. That she said that she didn't want Alex to know where her kids were, even if they were alive or anything. Can you guys remind me what you mean? Okay. That's going to be bothering me, though. Abby, hurry up and tell me what that means. Okay, on the phone with Melanie Gibb, Chad and Lori stated they didn't even want Alex to know where the kids were. However, at this point, they were already dead. Wait, what? Oh, yeah. Okay. Yeah, you're right. They didn't want, when they were pretending that they were in hiding or whatever, because I remember Pryor used that as an argument. Well, or wait, was he using... No, I thought he was using Melanie, her not wanting to tell Melanie, or maybe Alex too. Maybe she did say that too. Yeah, about how close she is with Melanie and Alex. And if she didn't even want to, share that with them, then he was kind of like implying that, well, then she, just because she was close with Chad, then she just wouldn't want to share that with people she was close to. If she didn't even share it with them, then, he was saying like, then how can you prove that she shared that with Chad, right? That girl, but Alex told Mel she didn't. Yeah, no, Alex knew, but remember, what did she say on the phone? Now you got me wondering. I remember her saying, I mean, we know Alex was involved with the whole thing, but we're talking about what Lori said on the phone, because she's lying left and right. So yeah, I think Alex was definitely involved in both of their deaths. But as far as what Lori said, I know she said she didn't want to tell Melanie because it was just better off that she didn't know. Like, it was almost like she's protecting her. We don't want, we'd rather not tell you. But did she say Alex too? That's what I'm trying to get to the bottom of. Did she say on the phone, now you got me thinking, that we didn't even tell Alex too? I don't know. I just remember Lori or Melanie. Did she say, oh, and I remember Pryor bringing up the argument about, oh, Lori's so close to, she doesn't want to tell people she's close with. She even wanted to keep it from the people she was close with, because I think he was trying to say, argue that Chad, or he's going to try to argue that Chad didn't know about it, because she didn't even share it with Melanie or Alex. But I can't remember if she said Alex. I don't know. I'm going to have to watch it again. Yeah. Oh, you're talking about Melanie and Alex. You're confused. I know that Melanie and Alex talked. I thought you were talking about Lori. Melanie confronted Lori about, Alex telling Melanie that. Oh, okay, okay. But why are we talking about this, Abby? I forget. What was the point of this? I don't even remember. Why did we start saying this? What was the argument to this whole thing? Not the argument. What were we even debating? What was the point? I don't even know, guys. I just lost what the whole point of this was. Oh my gosh. I don't know. I mean, what was the argument? Just the fact that they can blame it on Alex. Yeah, but that wouldn't. I mean, I know they're going to try to blame it on him, but that point right there wouldn't work as the opposite, though. What you were bringing up, right? That, to me, that's showing that they were saying he didn't know, even though we know he was involved. I mean, all the evidence points to him, but that conversation you're saying, it would be actually evidence the other way. If you would think about it, that wouldn't be a reason to blame him because she said that they don't know. Or are you just talking about the conversation with Mel? But the conversation with Lori on the phone, her saying that Alex didn't know, that wouldn't be good evidence to blame it on Alex. That'd be good evidence to go the other way, unless if you're talking about the conversation with Mel. That's why I'm confused. Wow, I better just go. I'm tired. Maybe I'm missing something. Oh my gosh. Lori said Alex didn't know, that they can't blame it all on Alex. Oh, I get it. Okay. Duh. See, I am tired. You're right. Good call. Yeah. Yeah. Wow. Good. Hopefully Wood brings that up. Lori lied to Melanie about what Alex said to protect Alex. Lied to Melanie that Alex didn't know. Wait, so Lori lied to Melanie about what Alex said to protect Allie. Let me put that up so we could, hold on a second, guys. Man, I think it's just too early without any sleep to, where is that comment? I wanted to put it up, so what I'm reading, but it's not even up there yet. So Lori lied to Melanie about what Alex said to protect Alex. Lied to Melanie that Alex didn't know. I don't know. I mean, of course, we'll see what everybody believes, the jury and what. So Lori to protect Alex. Yeah, I guess to just, I don't know. Yeah, you could look at it a bunch of different ways. I think that's what I'm doing. That's why I'm getting confused, because you could look at these a bunch of different ways. Like, oh, that could go for that. That could go against that. Lawyers could use these in different ways. You know what I'm saying? You never know. Sometimes the information, how they use it, sometimes you don't even expect them to use it that way. So yeah, I could see it. You go both ways, Betty. I don't know if that's what you're even saying, because I don't want to assume, because I've been screwing up what you guys are saying, but by reading her comment, it made me realize, yeah, they could use it in a bunch of different ways, I feel like. So yeah, I guess we'll just wait and see. Because some of you guys are saying that it would go for him. Protect Alex. Alex didn't know. Yeah, I don't know. I guess we'll see. So Abby, but real quick, are you saying that you think that they're going to use it for or against the Alex theory? Because when you're, maybe I'm looking at this word protect. Are you meaning, Betty, are you saying about Alex to protect Alex, like to protect him because he's the one that did it? Or are you saying it the way Lori referred to as, I'm going to protect you guys by not telling you? How are you meaning that when you say that? Because that's why I'm not sure if Abby's saying that you're going to use that for the argument or against the argument. That's why I'm getting confused. Because I could see it both ways. Now, I don't know. Oh, and reading your comment, I felt like you were saying it the opposite, which the other way than I originally saw it. Never mind, guys. I'm going to go to bed. My little buddy, I got a video of him. Oh, I don't know. I just want to see. Maybe I can send it to Zebra. She can show it. I think it will harm Lori, proving that she was a well wherever kids were. Okay. That's originally what I was thinking. And then I read another comment where it made me think the other way. I'm like, oh, okay. So that would be go the other way. But yeah, but you see how it could go both ways though. But you're right. Originally, I think I thought the way you were thinking, but I don't even remember now. My brain just went back and forth a bunch now on how I was looking at it. But yeah, that bottom line is you're right, Betty, because what he said to Melanie, and Melanie's going to be a witness. It already shows that Lori was lying, so I guess, yeah, they could look at it like she was trying to protect him. Okay. Yeah. So yeah, that's going to go against him if Melanie comes through, and still, I'm sure she's still going to be a witness for the trial. So yeah, because what Alex said to her, that's pretty incriminating right there, as far as at least him knowing where the kids were, and then Lori lying and saying, oh, he doesn't even know. Then it looks like she's like overprotecting him, like, oh, well, why is she lying about that when, so yeah, I guess we'll see. Hopefully Wood will pick up on some good tricks. Not tricks, but you just got to be really slick, in the courtroom, even if you got some evidence, and you just got to be good. So, all right, I'm going to go before I confuse anybody else more. All right, guys. Well, yeah, Heather, exactly. That's where I was going back and forth. See, this is what I'm going back and forth in my head, guys. I get what you guys are saying, Abby and Betty. I totally get it. But oh wait, no, I put up the wrong. Hold on, that wasn't the right comment I meant to put up, but that's a good comment too. But I wanted to put up your comment before that. Where is it? Wait, where is it, Heather? I just read it on my thing and now I can't find it. Gosh darn it. It just summed up what was going back and forth in my head, but I can't find your comment now. Wow, is it that behind on StreamYards? Hold on, I want to find her. Oh well, it's not that important, but that was my thoughts going back and forth. What she said in the simplest way, because sometimes I make stuff so complicated I can't even think. I make no sense sometimes. I mean I do, but I just make it more complicated than it needs to be. But I still don't see your comment. Oh yeah. Right here, yeah. So that's what's like, yeah, I was going back and forth this way, like, okay, well they'll use it against them. Oh, they'll use it for it. And but I get, yeah, Abigail and Heather. Hopefully Rob will be slick the way he, gets that point, if he even brings up that point, which I'm sure that'll come up with Pryor because he'll try to bring up something about it, and then hopefully oh Mandy, thanks. Hopefully, yeah, he'll do a good job at showing that it's a bunch of crap though. That it was all. Thanks, Mandy. All right, guys, I really am going. Wow, already an hour. I'm already been on an hour, and I think the hearing was only like. Oh, all right. I'm gonna go, guys. Everybody have a good day. We'll either chat tonight or tomorrow. All right. Thanks everybody for coming out. Mariani Bobani, Sad Soul, Cece. You think Colby will be a good witness? Really? I don't think he knows anything though to be a witness. He'll be a good like character witness or whatever, but he thought no, not really, because it's not about that, because he thought his mom was this great mom growing up. So I'm not sure what kind of witness he would be though, because he didn't really know any information. Remember, he was like on his channel like trying to like, mom, tell us something, like he didn't know anything. So it's not, I don't think he could help in the, I mean, he has a couple details about like, oh, he talked to Ty Lee and then it didn't sound like her. Her text sounded like it wouldn't be something Ty Lee wrote, and how she didn't want to video chat that day, which was weird. The one day, which it could have been after Ty Lee was gone. How Ty, I feel like he even said Ty Lee was kind of distant, like right before she moved to Idaho and stuff. But as far as like the situation, he didn't know anything. Remember, he was just in the dark as all of us. So I'm not sure if he'll really be much of like anything major as far as a witness. But I don't even know if they would necessarily for sure put him on the stand. Maybe just for like those few details. But I mean, I wouldn't even think they even would need to put him on to make their point. All right, guys. Yeah, I mean that's about as much as they would be able to get CC, but yeah, they probably will put him on just for that, I bet, huh? Yeah, Kathy, but yeah, I don't think they'll bring up those allegations or anything on that trial, but all right. Okay, all right, I'm gonna go for real now. Sorry, I was just reading some of the rest of your guys' text, but everybody have a good day, and I'll chat with you later. Bye, everybody. Wait, let me just answer. Rain answer no. I just mentioned. I know that they're not going to bring like a character witness and that, but I said that would be. I was thinking, well, what? He doesn't know anything about the case, so what? I mean, the only thing he could do is like a character witness. It was just kind of a joke. I mean, I'm sure that's not. They're not going to really need something like that, because he doesn't really know about the case. So no, I wasn't really being that serious when I said that. As far as this case, because that. I mean, why would they even do that for this case? But but then yeah, I guess they could do the text thing and that video chat. But I don't know if they'd even, do you think they would call him up just for that? He is on the list. Is he on the list though, the witnesses? I mean, maybe. I guess any little help to show. Yeah, they might just, to paint the bigger picture. I guess it's smart. Every little thing to paint, to show, like, to tell the story as much as they can. So even those little details of Ty Lee, his like experience with Ty Lee, I guess, yeah, it would be important. Anything, huh? Okay, bye. Ain't the answer. You're like, sleep. All right, bye.